Hello, I'm Patrick Hennessy, a Senior Associate in the Corporate team here at Mayer Brown. I'm joined by my colleague Mark Stefanini.
And I'm a Senior Associate here at Mayer Brown in the Commercial Dispute Resolution Group.
And today we're going to be talking about Endeavours obligations and clauses under English law. Well, contractual obligations are absolute unless there's some other type of qualifier. And so if a contractual term is absolute and it's breached, it enables a party to terminate and potentially claim damages for breach. So essentially, the parties can water down that absolute obligation by including an Endeavours clause. And what that means is that they will try to achieve a specific outcome rather than actually promising to achieve that specific outcome. And so then it's up to the parties to try and set parameters as to what that Endeavours obligation would involve and whether they have to be trying their hardest to achieve that obligation or just use minimal efforts to basically achieve that underlying obligation. And so that's what we're going to talk about today, as to what those concepts mean and how they've been interpreted by the courts.
Well, it's important to realise that Endeavours clauses aren't a panacea for circumstances in which the parties are slightly unsure as to whether they'll be able to achieve specific objectives. In particular, in order for an Endeavours clause to be effective, the object, the target of the endeavours has to be sufficiently certain. Where there's not sufficient certainty about what it is the parties are actually trying to achieve, then the clause is going to fail for uncertainty, regardless of whether it's best or reasonable endeavours. The recent case of Lyons and Bristol cars provides an interesting illustration of this. In that case, Lyons was under an obligation to use reasonable endeavours to enter into an agreement with a car restorer. But there were no specifics set out regarding what the terms of that agreement should be. And the court found that the Endeavours clause was too uncertain because there was no criteria by which to measure at what point it would be reasonable for Lyons to say, I am not prepared to enter into the contract on that basis.
So basically, taking Wolford and Miles' test, an absolute obligation to agree is unenforceable. And so obviously the court took the view that a reasonable Endeavours obligation to agree undefined terms with a third party was equally unenforceable on the same principles.
So the meaning of an Endeavours obligation will be arrived at by looking at the circumstances at the time the contract was made and what the parties must have intended. However, a party's compliance with that obligation has to take account of the circumstances existing at the time that a party is trying to use its reasonable endeavours or best endeavours to achieve the desired objective. So an Endeavours obligation, the actual nature of performance of it can change over time where there's an ongoing obligation.
And in that context, it's important to highlight that the different level of efforts used in performance of an Endeavours obligation is very fact-specific and depends on what is set out in the contract as well as the nature of the underlying obligation. So looking at best endeavours and what you need to do to satisfy that obligation, historically it looked like the courts were taking the view that basically you had to leave no stone unturned and basically you had to try your best to perform that obligation. And what that meant was best endeavours effectively wasn't your second best endeavours. You had to do all you could to do it. Subsequent case law took a different view and they basically said that best endeavours was not an absolute guarantee to performance and that you can look at other things that make up that obligation. And therefore, a best endeavours obligation means that the obligor must perform all reasonable steps which a prudent man would take in order to perform that obligation. Essentially, put yourselves in the shoes of the person you're performing the obligation for. What would they do in that situation to achieve the outcome that they actually want? And so you should take that into consideration. However, when taking that into consideration, it's not necessary to involve excessive expenditure that could ruin your business, save in limited circumstances. And there's also been case law to suggest that despite agreeing to a best endeavours obligation, directors of companies should still have regard to their fiduciary duties owed to shareholders. And in particular in that context, there's the Rackham case, where the company had entered into a share purchase contract and part of the completion obligations were to ensure that the contract was approved by the company's shareholders. In between the gap between exchange and completion, there was a change in legislation which meant that the contract was no longer of benefit to the company, and therefore the contract was terminated. And it was found that the directors had not breached the contract by failing to obtain the shareholder consent because the best endeavours obligation was subject to the fiduciary duties of the directors.
So in summary, when you give a best endeavours obligation, you are committing yourself to putting yourself in the shoes of the counterparty and seeking to perform as best you can the obligation that you have undertaken to perform using your best endeavours. Up to a certain point, you can incur significant costs, you can be required to accept losses as a result of trying to perform that obligation, but there comes a point, and the Rackham case is an interesting example, where it would be in breach of the director's fiduciary obligations to carry on trying to perform the objective. There comes a point where your own interest can take over and you can say, I have fulfilled my obligation, but I simply cannot achieve this purpose. So a reasonable endeavours obligation is appreciably less than a best endeavours obligation. The party has to take a reasonable course in pursuance of the desired objective, but does not have to sacrifice its own commercial interests in doing so. And an obligation to undertake to do something, use your reasonable endeavours to do something, doesn't necessarily involve taking all reasonable courses either. It may be enough simply to take a reasonable course of action and then say that you have performed the obligation.
Exactly. And as opposed to the best endeavours, the reasonable endeavours obligation is actually interpreted from the viewpoint of the obligor. What is it reasonable in their circumstances to perform the underlying obligation? The exception that we should mention in this situation is where the reasonable endeavours obligation actually specifies what steps need to be taken by the obligor in order to achieve and satisfy that test. That may involve additional expenditure, it may involve the obligor incurring loss, and then obviously if you fail to fulfil that obligation in accordance with the contract, then you could be held liable for being in breach of contract.
And this ties in with the general point that all of these obligations are always going to be interpreted in the surrounding circumstances of the contract. So in circumstances where you have a reasonable endeavours obligation but it specifies certain steps, what the court is really saying is, well, you, the parties, have set out what reasonable steps as a minimum would be taken, hence the inclusion of those steps within what is otherwise a reasonably dilute obligation. The question of whether a reasonable endeavours obligation goes so far as to require a party to commence litigation has been considered in the case of Tony Logo and Totem. In that case, the court found that where a party had undertaken to use reasonable endeavours to collect monies, that could amount to an obligation to commence proceedings in pursuance of that objective. However, it noted that there might well be other commercial factors that impacted on the decision to as to whether or not to commence proceedings. And given the nature of a reasonable endeavours obligation, the party performing was not obliged to ignore those commercial considerations in making its decision.
So having discussed best endeavours and reasonable endeavours, you'd expect a phrase that says all reasonable endeavours to fall somewhere in between. That's logical and what you'd expect. However, in the Rhodia case, the court said obiter that a reasonable endeavours obligation probably requires the obligor to engage in one course of reasonable action in order to fulfil that obligation, whereas a best endeavours obligation probably requires all reasonable courses of action to be considered and performed in order to achieve that standard. And therefore, a phrase that says all reasonable endeavours could equate to a best endeavours obligation. Jet 2 is an interesting case because it demonstrates that there may be situations where the obligor needs to ignore its own commercial interests in order to fulfil its obligations under the contract. The case involved a reasonable endeavours obligation on Blackpool Airport to support Jet 2's low-cost pricing. in the performance of its business. And the High Court held that that meant that Blackpool Airport was under an obligation to operate its airport outside normal business hours. And because Blackpool was in control of its own operating hours, the court found that the fact that operating the airport outside of normal business hours caused a loss to Blackpool Airport was irrelevant for these circumstances. So the ability to operate and for Jet2 to use the airport outside business hours was so fundamental to its business case and its low price business model that that's how the underlying obligation should have been interpreted.
There was some suggestion that the level of benefit derived by the counterparty to such an obligation may in some circumstances be taken into account. The example was given that if Jet2 could never hope to operate profitably out of Blackpool Airport, then the obligation on Blackpool to operate outside business hours in support of Jet2 might well fall away.
It's interesting as well about the case because when it went to the Court of Appeal, it led to a split decision. And one of the judges felt that the underlying obligation itself, the phrases around promoting the business and supporting the low-cost pricing, weren't sufficiently clear and certain for the reasonable or the best endeavours obligations to be satisfied. So is it better to stay clear of phrases like best endeavours and reasonable endeavours and use something else? You sometimes see things like best efforts or reasonable efforts incorporated into contracts, especially when you have a US counterpart. That's commonly understood in the US. But for the purposes of UK and English law, it's best to avoid using those phrases. It's been held that the use of the phrase best efforts equates essentially to a best endeavours obligation, and on the same basis, a reasonable efforts obligation will equate to a reasonable endeavours obligation. So for purposes of interpretation, it's best to stick with your endeavours language if you want to include that in the contract.
If a modification to a best or reasonable endeavours obligation is required, it's probably best for the parties to think about what actual steps they would require the counterparty to take, rather than to seek to use a general sweep-up phrase in order to provide them with certainty going forward.
And you often see phrases like commercially reasonable endeavours or reasonable commercial endeavours to try and water down a reasonable endeavours obligation or all reasonable endeavours obligation. That's fine, but it's clear to understand that there's very little precedent as to what that means in the context. And so it may be better just to use phrases like reasonable endeavours and, as Mark says, set out the steps that are needed in order to achieve that goal.
So the first thing to think about is whether the object of the clause is sufficiently certain. If that's not sufficiently certain, the clause itself will be unenforceable. Then I think one needs to think about what standard it is you're trying to use. And you have to choose, you can choose between the best, reasonable, all reasonable endeavours examples that we've discussed. If there are specific obligations, specific things that one party thinks the other party should do in pursuance of the relevant obligation, those should be set out as clearly and in as much detail as possible in an effort to avoid disputes about that later.
And in particular, if you're looking for a party to incur any particular expenditure or pursue a particular avenue such as litigation, then it's best to set that out expressly in the contract so that it's understood what the party needs to do in order to achieve its endeavours obligations. It may also be relevant to look to include a definition of best endeavours or reasonable endeavours in the contract if you can scope it sufficiently well enough. But obviously there may be different ways to define the obligations so that a reasonable endeavours essentially becomes a best endeavours obligation, and that will be subject to negotiation between the parties. Finally, the most important factor in trying to determine whether an obligor has fulfilled its obligations in respect of the endeavours clause is to understand whether the obligor has actually taken any steps to achieve its obligations. And so a prudent obligor would obviously record the steps that it's taken and inform its counterparty if it comes across any difficulties that would restrict it in performing what it's due to do under the contract. If anything in this talk has struck a chord with you, don't forget to take legal advice in relation to your own particular circumstances. Details on how to contact me and Mark are on the Mayer Brown website.